Welcome to this three-part podcast series focused on the key distinctions between U.S. and U.K. Euro M&A deal terms, the differences in M&A insurance products used in those markets, and the evolving convergence of M&A deal terms and insurance terms across the Atlantic. This series is targeted towards those M&A deal makers and advisors that transact primarily in Europe, the U.K., and the U.S. My name's Ted Caminas. I'm a cross-border M&A partner within the corporate team of the Global 10 law firm Eversheds Sutherland. I've had the pleasure of spending the bulk of my 20-plus year career advising on deals throughout Europe and the U.S. And I'm joined today by an expert panel of practitioners from the global market leader in M&A insurance, Aon, and the Global 10 law firm Eversheds Sutherland. This panel will share their deep experience and insights into the key differences in English, European continental, and U.S. M&A practices and insurance products, and the evolving convergence of what we call transatlantic terms for both. Let's get started. Christina, we've had the pleasure of collaborating with one another for over 20 years on transatlantic deals of all sizes and types. People often talk about the big differences in M&A styles and practices amongst the U.S., the U.K., and European deal makers. Based on your deep experience, what are some of the key differences that particularly stand out to you?
Hi, everyone. I'm Cristina Odran-Troca. I'm a transactional lawyer having practiced, as Ted was saying, for almost 20 years in cross-border M&A across various sectors. And for much of that time, I had the pleasure of tag teaming with Ted many exciting transatlantic M&A projects. I'm a partner in Eversheds Sutherland's corporate team in Paris, and I regularly practice English law on cross-border deals. So Ted, to your question, there are many significant differences. Overall, SPA deal terms are traditionally more buyer-friendly in US M&A and more seller-friendly in European and UK M&A. And the parties and their counsel try to play those differences to their advantage when negotiating transatlantic deals. I'll pick on just a couple of those differences, which are particularly relevant in the context of W&I insurance. Firstly, the basis of recovery for rep and warranty breaches. In US style M&A, if a rep and warranty is breached, recovery by the buyer is on an indemnity basis. This means that the buyer can make a dollar for dollar recovery of its losses. That's not the case in English law governed European deals, which are the majority of the deals in Europe in a cross-border context. Perhaps in respect of pre-completion taxes, you can see that recovery is on an indemnity basis, but for the other warranties, buyers would only be entitled to a contractual claim for damages. So in an English deal, the buyer would only be able to recover the decrease in value of the target shares that results from the warranty breach. And it would only be able to do so to the extent the losses that it incurs were reasonably foreseeable when the SPA was signed. Of course, in English deals, there can be specific indemnities, but they only cover specific identified risks. And the indemnification wouldn't apply across the board. So it may be more difficult for a buyer to recover all of its losses in the event of a breach under an English law SPA than under an American law SPA. This also means that usually in English style deals, the buyer puts more emphasis on the due diligence phase. Secondly, I'll mention disclosures as another area where there are significant differences between US and European M&A. In the US, only what's set out in the disclosure schedules attached to the SPA are considered disclosed, meaning that they represent exceptions to the representations and warranties, and the buyer cannot bring claims for those. Those exceptions are very specific and very narrowly defined. But in English law governed European deals, it's common practice to see general disclosures, such as disclosure of information available in the public registries, but also more importantly, a deemed disclosure of all of the information provided by the seller in the data room. This would be very unusual in a US deal. And to balance that, usually in European M&A, there's a requirement for fair disclosure in order for the disclosure to be effective, which gives a certain level of comfort to US buyers transacting in Europe. Lastly, I'd mention conditionality is also different. In US M&A, there are wide-ranging conditions precedent to closing. Material adverse change, bring down of warranties, compliance with covenants. These are not customary in European M&A, where conditionality is usually limited to obtaining regulatory or merger control consents. Material adverse change clauses, for instance, are far less common in Europe, and if they are included, they would be usually very narrowly defined and specifically tailored to the target. And in some European jurisdictions, such as the UK, it's also less common to repeat reps and warranties at closing, except perhaps for the fundamental warranties. And there are many other differences in terms of how the deals are structured, as well as various SPA provisions. And in transatlantic deals, we often see a mix of US style and English law style provisions and approaches, as much of this ultimately depends on the parties' bargaining powers. Ted?
Thank you, Christina. Very interesting insight. Gavin, you've been at this a very long time yourself, often advising American clients that are inbound into Ireland or springboarding from Ireland into Europe, as well as representing Irish clients doing deals in both the US and in Europe. Based on your experience, anything you'd add to Christina's observations? Is it the key differences between American deals and UK, Irish, European deals?
Yeah, thanks, Ted, and thanks, Christina. Just by way of background, as I say, I'm Gavin O'Flaherty, a corporate and M&A partner here in the Dublin, Ireland office of Evershed Sutherland. We also have an office up in Belfast, the capital of Northern Ireland. Likewise, practicing over 20 years in transactional activity in and through Ireland. And Ted, just to mention on the question, I think while there are huge continental and gravitational pulls to bring the two jurisdictions together, particularly in the realm of Ireland W and W&I policies, I might just highlight, to add on to Christina's excellent points, some additional differences that US buyers or continental buyers can come up to in the Irish jurisdiction. I suppose the first one is the basis upon our documents, whereby they're based on the common law jurisdictional transactional documents, so they can appear quite wordy and lengthy to US buyers at time. And brevity can sometimes not be the key, where, for example, we could have 4 warranties when maybe one would suffice. So I think what we are seeing here in the Irish market, particularly where Ireland W and W&I policies are coming in, is the concept of a US style stock purchase agreement making its way into our lexicon of drafting. Particularly, as I say, where W&I and Ireland W policies are on the pitch, whereby, and in addition, you can also see that buyers can also seek for those documents to be under English law, which there isn't domestically here in Ireland too great a resistance to, given the huge similarities between our respective jurisdictions and the base upon our legislation as well. I think, which is a current hot topic, obviously, here in Ireland, given the Apple case, I think tax is a very important issue here in the Irish market. It can sometimes be the reason, or one of the reasons, why foreign corporates are either setting up or acquiring here in the Irish market in the context of our low corporation tax regime and some of the reliefs available. So in the context, and it's the point that Christina mentioned earlier, we would usually provide for the covenant or the indemnity in favour of buyers in respect to the pre-completion tax liabilities of the tax target or the target company or group to be dealt with by way of a standalone tax deed of indemnity or covenant, thereby giving enforcement on an indemnity basis regarding pre-completion tax liabilities. This document would have generally a long-form general covenant, and thereafter would have specific covenants for highlighted DD tax risks that were highlighted during the course of due diligence, which we might touch on later in some of the subsequent questions as regards recoverability and coverage of those under the R&W policy. I think, like Christina mentioned, I think Europe and Ireland, by its nature, is probably could be viewed upon by US buyers as probably a little bit more seller and employee friendly. So one example of a difference that US buyers can struggle with is the limitation we have here on restrictive covenants, whereby it's probably the rule of thumb that 2 years is probably the maximum permissible period, say for where the relevant seller might have developed intrinsic IP, which is vital to the group, whereby a 3-year period might be permissible in that regard. But again, it's closely monitored by our Competition and Consumer Authority here in Ireland. And in addition, in the context of ensuring enforceability, a shorter period for minority shareholders would be probably recommended in that regard. And as I say, I think there can be local quirks here as well, in the context of the US buyer expectations, where you can sometimes see in US stock purchase agreements, Ted, you can speak better to it, but a sharing of liability for transfer taxes. But that generally is not the case here. It's usually a wholly buyer liability, the payment of transfer taxes here, which is usually borne at the rate of 1%. And in fact, it was the sharing of liability for that liability was until quite recently expressly forbidden here in the Irish market. So again, it can be an upskilling of knowledge for US buyers, but it's just part of the factor of doing business abroad and various local and transaction issues that people will encounter here in the Irish market.
That's great, Gavin. Simon, you're based in London with Aon and often are at the forefront of working with US M&A deal participants and UK Euro deal participants. And unlike us lawyers here at Eversheds, I really only have the benefit of experiences that we or our colleagues or our clients have within one firm. You're more actively seeing deals across scores of law firms and tens of sellers and buyers each year. So based on that broader perspective, what are some of the key features that distinguish deals on both sides of the pond from your perspective?
Thanks, Ted. And just by way of introduction, I'm Simon Tesselman. I've been at Aon for more than 20 years, most of the time doing W&I or reps and warranties or some combination of the two. So it's been really interesting to see how this market has developed and how we're starting to see some of these convergences, which we're going to talk about on this episode, and I think a bit more in future ones. So I thought it might be useful just to sort of set the scene as to kind of how these two products grew up in the first place, and perhaps to say, in reality, although they are separate products, they are at a fundamental level covering the same thing. So fundamentally covering an insured party for a loss that arises from a breach of a rep or a warranty given in a sale agreement. I think sometimes there's a view that they're two entirely separate things covering different matters. So that's not the case. They are fundamentally the same. I think I'd like to sort of mention that there's probably three key differences in the products, and that's partly technical, partly sort of process or practical, and partly economic. If we start with the sort of technical, the products, I suppose, in each respective jurisdiction grew up largely as a function of what the SPAs look like. So to sort of talk to previous speakers' points, in the US, very common not to have a data room disclosure. So policy would therefore follow the same position, whereas in UK and Europe, very common to have a VDR disclosure. So the policy would sort of automatically follow that position, because ultimately what we're trying to do is replicate the position the buyer would have had under the SPA in the absence of insurance. So I think for many years, those two things grew up entirely sort of independently of each other, and there's sort of no need to mix the two concepts. Secondly, I think in terms of process and practicality, it's become more normal in Europe for underwriters to sort of look at these deals and pose their questions in written form to the insured parties. And then the insured would provide written answers. Sometimes they might use their advisors to help them do that. And that information all flows back to the insurers, who then may have an underwriting call, not always, but would have an underwriting call and do some follow-ups on those questions. In the US, it's much more kind of orally done. So there is typically no written questions, and there'll be a 1 to 2 hour underwriting call, where perhaps the underwriters will focus on a bunch of sort of themes or topics they want to get into, but won't go through a very prescriptive list of questions, which is a little bit different again from Europe. And then economically, typically the two jurisdictions have been some way apart. Historically, pricing in the US for these policies was around about 3 times what it is in Europe, with deductible or retention levels around about double. That sort of delta kind of comes and goes from time to time, depending on market conditions, but there is still a significant gap in pricing, and that's partly reflective of the more buyer-friendly natures of US SPAs and policies, and partly it's just a function of the price or the floor that the clients will find acceptable with the insurers. So that's just more of a market practice, a market condition thing. If we turn now to sort of beginnings of the transatlantic cover, I think really that arose from when US buyers who, having now bought a number of R&W policies in the US, quite familiar with how they looked, what they cost, and how to buy them, came to Europe and found some of these differences a little bit puzzling. Typically very unfamiliar with some of the deal terms that Christina would talk about, most particularly sort of the VDR disclosure, but certain other sort of deal terms that they didn't particularly like, and certainly then didn't like that being replicated in their insurance policies. So I think the starting point for the transatlantic coverage was if the US buyers could sort of, I think, ideally have a US law agreement, but if they couldn't have that, certainly have more of a US style agreement. or incorporating some of those features, and then insurers in Europe would then sort of agree to follow that position, thus getting to a more of a kind of US style policy. But in the sort of early days of the convergence, you very much had to have the underlying transaction documents in that kind of US form for the policy to follow. I think that's changing a little bit, but that probably is a discussion for the next episode, Ted.
Thanks, Simon. And many thanks to our panelists, Christina, Gavin, and Simon from Eversheds and Aon for sharing their learned insights into the key differences between M&A deal terms in the US, the UK, Ireland, and Europe. That wraps up the first part of our three-part podcast series. Join us next week as we continue with part 2 of this podcast series as we explore some more of the different approaches and terms that pertain to M&A insurance products on both sides of the Atlantic. Thank you.